The court will note for the record that this matter is being heard today using Microsoft Teams for this appearance. All appearances are by video or by audio at this time. I just wanted to clarify, who is calling under numbers 518428?
I am.
And can you identify yourself again? Because I'm just trying to make sure I have a record of everything that's going on.
The last four digits of my number is 5998, sir.
Yes, ma'am.
And it's Elaine Wood.
Elaine Warden?
Wood, W-O-O-D.
Thank you very much, Ms. Wood. And caller under 0624, can you identify yourself as well?
Yes, this is Diane White.
Okay. Thank you very much, Ms. White. Okay, this matter is on today for continued proceedings involving the violation of child support proceeding that has been filed by Ms. Rucci. Counsel, so the court will note for the record that the court just had a conference with both counsel as I was getting to discuss an issue. We are on the record now. Counsel, let me ask you a question. So I was addressing the issue of personal service in this matter, or service in this matter, and personal jurisdiction. It's an issue that the mother, Ms. Navarro, raised when she first appeared in my part in this matter. And so I'd like to address that point. Mr. Gilden, I don't see you on the screen right now. I think there are too many people here, so I have a lot of court observers, but I don't have Mr. Gilden, your face on the screen right now. Mr. Gilden, can you say something? Because I think the mic will pick you up, and then I think your video will.
Yes, Your Honor, I'm here.
Okay. Okay, there. Okay. And Ms. Sodi, can you say something as well? Because again, the court observers are all sort of.
Yeah. Yes, I'm here. Could the other parties mute themselves?
I'm sorry?
Could the other parties not mute themselves?
Or can they mute themselves? Okay, yeah, yes, yes, thank you. Okay. So I have a finding of willfulness that was entered by Support Magistrate Rosario, and it's a finding that Ms. Navarro willfully violated the order of support that is in effect. There has been an argument made by Ms. Navarro before this court that there is no order of support in effect. In that argument that has been made, the court has denied and does not adopt at this point. There is presently an order of support that is fully in force and effect, according to my read of the file. And there were previous statements made by Ms. Navarro that the order of support is not in effect, and that even one of the support magistrates may have made an argument or statement to the effect that there was a force order. The court wholeheartedly rejects that position. I have checked the file, and I do see that there's an order of support that is in full force and effect. So the question is how to proceed forward at this time, and this matter is on my record today for confirmation. I did, in review of the file, again in preparation for today, did review the different affidavits of service, and I just wanted to address the argument that the mother did raise originally about personal jurisdiction. when she first appeared before me, as I indicated, I think may have been back on February 9th, she indicated that the court did not have jurisdiction over her and that she was appearing solely to contest jurisdiction. Mr. Gilden, let me ask a question. So the support magistrate Rosario received 2 affidavits of service into evidence. One was an affidavit establishing suitable age and discretion service, and that was the original affidavit of service that was submitted to this court. And support magistrate back, I think it was in December, found that that affidavit or that service wasn't properly effectuated because it didn't meet the 8-day requirement that the Family Court Act does set. So at that time, she authorized nail and mail or fixed and mail service at that time. Okay, Mr. Gilden, let me ask you a question. And then I believe that there was an affidavit of service submitted to the court establishing that a fixed and mail service was established at that time. And that was submitted to the court on or about January 19th, I believe, and that affidavit of service is in the system as well. Ms. Sodi, my understanding is that subsequent to that, your client does file an order to show cause. As I review the file in the system, that she does file an order to show cause, seeking to hold seeking a Travers hearing. Is that correct?
That is correct, Your Honor. I was not her attorney at the time. I'm not sure if she was pro se. I'm not sure if she understood what steps she should take upon that denial. She is disputing service. The affidavit is vague and does not specifically address the specific times, days, and whereabouts of where the attempts were made. So she's asking for a Travers hearing. She's actually asking for this petition to be dismissed for several reasons. I mean, one of the germane reasons is the lack of service, but also lack of jurisdiction. But as far as service, she has a very big, she denies that those attempts were made.
Okay, and then I see that the support magistrate Rosario declined to sign this order to show cause on May 24th of this year. Ms. Sodi, let me ask a question on the part of your client. Did she take any action pursuant to that denial?
I am not aware. I'll have to let her answer that. I was just assigned, I think, a few days later, or was that the day?
May I answer?
Yes.
So the decline to sign was remitted back on 5/24. On 5/23, we were here in court, and that is the day that Ms. Sodi was assigned. You assigned Ms. Sodi. That was the day that the former counsel, Mr. Agua, had his motion for withdrawal heard by this court.
And was there any action taken on that denial to sign the order to show cause?
On the denial, no, because Ms. Sodi had been assigned the day before. And also, this is the first time I am hearing of any affidavit of service filed in December or submitted in December, and that was the issue. Yep, yes, because at the time when I first appeared in this court on February 9th, there was only one affidavit of service, and that was the nail and mail. And that was again restated by Mr. Agua on April 25th before this court, before Your Honor. He reaffirmed that there was only one affidavit for nail and mail. So again, I have no idea what affidavit of service was issued in December by Mr. Gilden, and I'd like a copy of that because I requested all affidavits of service from the file from Mr. Agua back in March and before the April hearing, and that was nowhere filed, none. So that's really interesting.
Mr. Gilden, what did you want to, what's your position on service in this matter at this point?
My position is it's not germane to this proceeding at all. What happened upon information is belief is that in order to correct short service, a fix and mail was ordered. That's all. Just on short service, not on notice. Notice was properly given. There was an appearance. It was only to rectify the 8-day short service. So there's no need to justify anything at that point because there was an appearance, albeit perhaps limited at that point because of the short service. But again, the real point here is there was a decline to sign order to show cause made in May. There is a track for a remedy or series of remedies that has nothing to do with this part. This part received an order and it has to act on that order. There's another remedy if there wants to be a pursuit of an appeal, which has not happened. I don't understand why this is being introduced in this proceeding. It's a completely separate proceeding. There's still an ability to make that appeal should they want. The appellate division will entertain appeals at the appropriate juncture, regardless of what the trial court does. It doesn't become moot because of the finding of willfulness. So the appeal can be had if the appellate division will take it. There's a mechanism. The mechanism does not lie within the trial court to reach on this issue in any way. There was an election of a remedy. The remedy chosen was an order to show cause. That's the track. It has nothing to do with this proceeding here. The bottom line is child support has not been paid. It has not been paid at all up till the disposition order. It has not been paid since. That is the overreaching priority of this court, regardless of other technical procedural aspects. The due process rights of this child are paramount. There's been an election of remedy. To introduce this issue now at this very late juncture is not appropriate, Your Honor.
Your Honor, if I may speak, Family Court Act 453C, you cannot issue an incarceration order on a default. So Mr. Gilden is incorrect. That issue was blatantly stated several times. And the child has been residing outside of this country for over 1 year, and we're going on 5 months.
Judge, just to clear the record, this has nothing
You
to
have
do
been
with...
suborning perjury, claiming that he lives in
Counsel,
Queens.
Counsel, Ms. Navarro, please stop. Mr. Gilden, give Ms. Navarro, please give Ms. Navarro an opportunity to finish what she's going to say, and then I'll hear you.
Various times, Mr. Gilden has watched his client appear in court and falsely swear to residing in Queens. He does not reside in Queens. He has not resided in
Okay,
Queens.
Counsel, Ms. Navarro, Ms. Navarro, that issue is not.
Venue, had he wanted,
Judge, everything
Would
coming
have
out
been
of
in
this
Suffolk
party's
County.
mouth
Ms.
is
Navarro,
not
Ms.
correct.
Ms. Navarro,
You
I'm
are.
not addressing, Ms. Navarro, I'm not addressing that issue right now. That is not the issue that is before me right now, so.
As far as the recitation of the legal standard in this matter, I can't even say let's agree to disagree. It's wrong. Whatever the party is saying is wrong. It's clouding the record. She has an attorney. She should not be able to make legal arguments on her own behalf. She has to pick a lane because it's clouding the record, and the statement as to not being able to send somebody to jail on default is false.
I'm aware of that, Counsel. I'm aware of that.
Your Honor,
Family Court Act 453C is very
It's
clear on that,
false.
unless it
You
has
are
changed.
Counsel,
wrong on the
okay,
law and
okay,
have a
so
lawyer.
No one speaks until I say you can speak now. Okay, do not do that with each other. I said don't interrupt each other, and it's not going to continue to happen on my record.
Your Honor, may I
No,
make a...
no, you cannot. No, the public
Okay.
cannot make a statement in a courtroom. That's not how this process works. People do not just come to court and just say, I want to speak to in the court process, right? That's not how, and we all know that.
All right, Your Honor.
the public has the right to be present, and the public has had that right in these proceedings throughout the time that I've had this case. That is not an issue, but the public cannot make statements on the record to address legal issues being discussed.
Service and due process is my client's constitutional right. It's more than just a technicality. Her freedom is at stake here. And if Mr. Gilden wants the order to be paid, it would behoove him to have my client not incarcerated so that she can make payments on this order.
Judge, in response to that, the payment made to date up to including the order of disposition was zero. The payment made in the 8+ months since the order of disposition has been zero. I can see that the party has a home, eats, pays expenses. You can't basically, I don't know how to say this, just completely disregard this court's order. If we're going to disregard court orders, we might as well just shut it down and have no court system at all. The payment made has been zero. Not paying what I can over time on a very small needs-based order, not paying $1 or $100 a month, zero. That is the quintessential definition of contempt. That is the most contemptuous act one can make. We have a court order and I say no, the law doesn't apply to me. It's not a question of can I afford this, and I'm making every best effort to do what I can to abide by the order. This is disobedience to the largest degree. And for the sanctity of the system, it must be enforced. For the well-being of this child, it must be enforced.
Great counsel.
Your Honor, and I'd like to just say that on February 9th, 2022, when I first appeared before you, Mr. Gilden could not prove when the actual July 7th order that is in question was served.
Ms. Navarro, I've already indicated to you that that order of support is in full force and effect based upon my read of the system, my read of the notes from those appearances that appeared, counsel. So, Ms. Navarro, that issue is not being addressed by this court. The court.
But Your Honor, the quintessential aspect that Mr. Gilden was indicating and was proclaiming is notice, is defiance of an order. And it has always been the case that there was no proof that I was served or knew of an order from July 7th. And that still hasn't been shown.
So that my reading of the notes from these from that underlying docket is that there was a motion, and that in fact this court has delayed the process, not delayed, but granted Ms. Navarro an opportunity to file any motions to vacate default judgments that she wanted to file in this matter. So when the matter first came to me, and after I signed counsel, I gave her an opportunity. I've given Ms. Navarro an opportunity to file the respective and the proper motions to vacate underlying default judgments, including for the underlying order of support that went into effect back in July of 2021. My understanding is that that motion was heard by the support magistrate, and that motion has been denied, and that that now is being appealed at this time. So that's the proper remedy for that docket. And
But there was a second jurist who said no. The objections came back the same way. So it's already been two jurists that said no.
Yes, Mr.
There'll
Gilden.
be a third panel of jurists.
Mr. Gilden. So what I'm saying is that issue is not before this court at this point. There's an order of support in full force in effect, and the court has indicated that up until now, today. So
the question is service on this violation petition, and if she was adequately served, then counsel can give an affidavit or an affirmation with the details. In the meantime, my client has not been disobedient. She has been challenging the order. Now that the order is, technically while this appeal pends, the order is still there. I will advise her to make payments on the order. It's not an issue of her disobedience.
Judge,
so today, counsel. Okay, so today, stop. Mr. Gilden, stop, and Ms. Sodi, stop. So this is what we're doing today at this point. So the court, again, did address the issue of service because the mother did raise that on this docket back on February 9th when she first appeared. She indicated, as I said before, that she was appearing solely to contest jurisdiction of this on this matter. And the court did take a look at the affidavits of service and did inquire about whether or not there was proper service. She did file a motion for a traverse hearing that was denied by the support magistrate in this matter. And that motion, in order to show cause, I apologize, and as she just indicated before and acknowledged that denial took place on May 24th of 2022. If the appellate division if the proper remedy there lies in the appellate division pursuing or that being appealed, then the court will allow that process to take place. But then I have this matter that's before me at this time. And what I'm going to do today then is I'm going to confirm the finding of willfulness that was entered back on February 2nd. And what we're going to do is we're going to adjourn this out for the mother to come up with payment. I did check the other day, and I do have an account statement that has been set forth in the system. It is dated October 6th of this year. And the amount that the account statement indicates that is owed at this time, according to the support collection unit, is $14,468.77. That's for an account statement that is dated October 4th of 2022. When this matter was referred to this court back in February for confirmation, the outstanding arrears were amounted to $10,287.43. So the arrears amount is clearly going in the wrong direction in my part. What I'm going to do is adjourn this matter out for the mother to Ms. Sodi to come up with a lump sum payment to reduce this amount of arrears. At this point, I'm probably looking at a number about $10,000, counsel, for her to come up with and pay to avoid the commitment order that is being recommended by the support magistrate. So I will give her an opportunity to come up with a payment, and let's see if she's able to do that within the period of time that we're going to come back. And if not, then I will start to address the appropriate relief that is being sought and whether or not the court will commit her for the 90 days that is being recommended. The court can incarcerate or commit Ms. Navarro for anywhere between 0 days to 6 months. And so I will consider all remedies before me, counsel.
Your Honor,
I was not able to get the A&R statement. Could the clerk send that to me, please?
I will
Your Honor?
have the clerk forward it to both counsel, okay? And if you can access that original or affidavit of service, I will have that forwarded to you as well, counsel, okay? Let's adjourn this matter out. We're going to go out about,
the A&R statements for 815 and 928, my attorney has indicated she does not have privilege to view, and so those are important for her to have.
Okay, I can have those forwarded to you. Ms. Sodi, you can't access any of these documents?
No, it says I'm not eligible to view this.
The A&Rs are not available through regular UCMS.
Okay, so then I
That
will
is
forward.
incorrect, because
I will-
Mr. Abua had previously
I
sent
will-
them.
I will forward those to counsel, okay? Okay, let's come back. It's October 11th. I'll give you about 6 weeks to come up with this $10,000, a minimum of $10,000, counsel, Ms. Sodi, okay, for your client.
I will be filing a stay, and I'd like to, and Your Honor, if you're
Well,
going
I'm
to
not
send.
issuing
you'll
an
be
order
able to
today.
see-
Ms. Navarro, Ms. Sodi, I'm not issuing an order today. This is what I'm saying. I'm suggesting that she come up with. She can appeal my order once I issue an order of commitment with the purge amount that's set. But today we're just talking about this to give her an opportunity before I have to take that extreme measure to enforce the order of support. How is November 21st at 10 o'clock, counsel? And Ms. Sodi and Mr. Gilden, but Ms. Sodi, make sure that your client knows that I am someone who will commit someone for a period of a parent who is not paying his or her child support, okay? And it has happened in my part numerous times. So if she doesn't pay, then I will be forced to address whether or not she's going to go in, especially if she's not paying any money.
Judge, I would ask two things. The party has made it infinitely clear that she's not paying this money. She's going to do everything in her power to appeal, to do everything. She's not going to pay this money. I would ask that we dispense with any further delays and just get right to it, and she can appeal the order instead of having another delay, Judge.
Well, in that
Can-
case,
can-
Your
stop,
Honor,
stop,
I'd
stop.
like to, no, because Mr. Gilden, let's go back to April 29th.
Judge, who is,
No,
No.
stop.
Mr. Gilden, no.
Both of you stop. I'm going to remove people from I'm going to start removing people from the courtroom. No, that's not how this works. I've said what I'm going to do, and that's what I plan on doing. Mr. Gilden, I always give a respondent an opportunity to come up with the amount of money that I'm suggesting in order to avoid commitment.
and
So that is what I'm going to do here.
is it appropriate then to convert to an in-person appearance on the return date?
If you want all appearances to be in person, that's fine, counsel.
Well, if we're going to, I don't want to react prematurely, but if
But
there's.
Mr. Gilden, what I will do is I will issue a warrant for the respondent. That's how I do this, counsel.
That's
Once I
fine,
know
that's
that,
fine, understood.
if I know that a person is not paying and he or she is not present, I will issue the warrant, and the New York City Sheriff's Office or the Nassau County or Suffolk Sheriff's Office will go pick up and bring them to my courthouse, and then from there I commit. November
I am-
21st at 10 o'clock.
I'm
And I
engaged.
object to that, Your Honor, because I've been to every single court appearance here. So if anybody has an issue with not appearing, it's Mr. Gilden and his client who weren't here for no
The
reason on
warrant-
August 18th and
Miss-
July 11th.
Ms. Navarro, the warrant is not because you haven't been appearing, but because you will be committed as a result of not paying. That's why the warrant
Well,
is issued.
that
I'm
was
not-
the
I haven't
warning
issued- I
That
haven't
was
issued
on
any
also
warrants.
February 9th.
I haven't
remember?
issued any warrants.
I got a notice of warrant. That's how I appeared in court on February 9th, and I saw no warrant.
How did you get a notice of appearance on February 9th?
I got a warrant. I got a notice of warrant, which is why I appeared, and that's what I stated.
Where did you receive, at what address did you receive it, ma'am?
It came through email. It came directly to my inbox, a notice of warrant, and I never saw a warrant. So that is one of the things that I stated on the 9th when I first appeared.
You understand that this is just an admission of the inevitable here?
Admission?
Service was
Mr.
fine. there
Gilden,
was
I
an
would like to go
appearance.
back to
was-
April
Okay, Miss
29th.
Navarro, Miss Navarro, Mr. Gilden, we're going to be back in court on November 28th, and you said, Miss Soto, you're not present on November 21st, November 28th at 12 o'clock.
November 28th at 12?
Yes.
Can I check that, please? At 12 o'clock, okay.
Okay, November 28th at 12 o'clock for conference status, updated status, and on that day, I will address whether or not the payment has been made. I will order the account statement for that court. The matter is concluded November 28th
Your
at
Honor,
12
one
o'clock.
question. Mr. On the confirmation of the order, Mr. Gilden had indicated $2,000 for attorney fees. As of
Actually,
every single
Mr.
previous court appearance, I didn't see a bill. Mr. Gilden?
Mr. Gilden, yes, Mr. Gilden, let me address that. I am not confirming that part of the order. My position on attorney's fees is that I do need to see not just the retainer agreement, which is what I reviewed in the system. I didn't see any bills for that, so you do need to submit. That's how I address that, counsel, okay?
It's part of the underlying order, and it was part of the underlying hearing. I don't know why I would have to remove that.
Mr. Gilden, how many appeals have
All
you
right,
lost
Navarro,
on that
stop.
amount, on that
Do not
that
interrupt my
aspect
record.
alone? That Nelly?
Judge, my bill is so far north of $2,000. So now that you poked the bear, I'm going to withdraw my, if it's fine with the court and if it's clean procedurally, I'll make a new motion for attorney's fees to encompass the inordinate amount of resources that have had to be expended on this matter.
I'm not taking a position on that, counsel, but if you want to file a new motion, that's fine, but I just need, you know the case law, counsel.
Yes, I do.
I need a billing statement to show that what was done in order for me to order the order.
It's just for the court's purposes. There's not always a billing statement because sometimes support cases are done on flat fees, which are entirely permissible.
That's fine. However you want to explain it, that's fine, but I just need to see the record to make sure. I did review the retainer agreement, and I did review that, but I don't have any any statements that were associated. So if that's your
The
position, you
retainer
need to...
agreement is a self-proving document because it's a flat fee for that case.
I will review it then, counsel, if your position is that it's a flat fee in this matter. Okay?
Can I ask why the party is wagging her finger? and
Counsel,
making-
counsel, I'm not,
It's so bizarre.
counsel, I understand, counsel. I'm counsel. Let's stay focused as professionals on this matter, okay? November 28th. If you want to file a new motion, that's fine for attorney's fees. If you want to address it the way that you were saying that it's a flat fee, then I will review that in that vein as well. Okay. November 28th at 12 o'clock. Okay, thank you very much. This matter is concluded.
Thank you.
All right, good day.
Wait, sure? Hey, what are you doing that?